everyone, and welcome to our ATAR Notes lecture for today. My name is Jess, and today we're talking about QCE Legal Studies, Units 3 and 4. Thank you all for coming along. Before we get into our content for today and a little bit more about me, I wanted to introduce you guys to ATAR Notes for any of you who may not know about us. This could be your first lecture series with us. So we've been going since about 2007, and our lecture series have been going since about 2015. We do have lots of other free resources available for students, so I wanted to give you some examples of those. They are all available on our website, atarnotes.com, so I recommend checking the website out to see if anything would be helpful for you for your studies. So in addition to lectures, we've also got online Q&As, we've got videos, ATAR calculators, articles, and study notes. So if you feel like you need a little bit more help in any of your subjects, whether it's legal studies or any of your other subjects, then check those out. We also do have tutoring, both private tutoring and class group kind of tutoring. So also, if you need sort of one-on-one help or group help, then that may be something you're interested in too. And you can see that we've got resources through what we call ATAR Notes Plus. So we've got a whole bunch of text guides and study guides. So these things are based on the syllabus and they take you through everything you need to know. So we do have one dedicated to legal studies, so that can be something that can really support you on your journey through the rest of Year 12 legal. Okay, so without further ado, let me tell you a little bit about me before we get started. So as I mentioned, my name is Jess. I graduated in 2020 from school, and I'm currently studying communication and journalism at the University of Queensland. I've just finished my third year of that, and so next year will be my final year. That's 2024 will be my final year. And I love reading and writing, so that was always my sort of thing at school with the different subjects that I chose, English and electives like legal, business, and accounting. Now, a little bit about our lecture schedule for today. We are going to go through a bunch of content that you need to know. So you need to be able to understand and describe and explain a whole bunch of different concepts. And we'll go through all of those to begin with. This lecture all follows the syllabus. So we're going through everything that the syllabus says that you need to know as part of Unit 3, Topic 2 for legal studies, because that is something that's probably coming up for you at school. Every school does it differently with the way that they structure the different units and when they teach them, but for many of you, this will be what you'll be working on next at school. And once we've gone through all of those content-based things, we'll then have a bit of a look at your inquiry report assignment, which is the piece of assessment, your IA2, that you'll do for this unit. So we'll do an overview of that. We'll look at some of the terminology that's in the criteria. We'll look at the structure of a report, how to approach different report sections, and we'll have some examples that we'll look at that are from the report that I did when I was at school. Okay, so let's get started. So first of all, we're going to be going through and just describing a whole bunch of key terms that you need to know. And this is all about being able to understand things and describe them using legal terminology. So commissions is the first thing that we're going to look at. So at the federal level, the Australian Law Reform Commission has the function of reviewing our laws and making recommendations to the federal government on what should change about the law. And at the state and territory levels, this role is the responsibility of a whole bunch of different state and territory law reform bodies. So in Queensland, we've got the Queensland Law Reform Commission. Now, law reform also occurs through royal commissions of inquiry, and we'll have a look at those as well in more detail. So, a royal commission is a government inquiry, and it's established by the Governor General. And the role of these inquiries is really important to address the sort of key issues that are current in Australian society. Oftentimes, the findings and the recommendations that result from those end up producing some important law reforms. So, we'll have a look at some examples today of different law reform royal commissions, that have occurred, but different big events that have happened often result in a royal commission. Now, a parliamentary inquiry is an investigation by a parliamentary committee, so a group that is comprised of members of parliament, into an issue of political, social, or legal interest. And advocacy is any action that speaks in favor of, recommends, argues for a cause, or supports or defends, or pleads on behalf of others. It can be written or oral. Now, that is a bit of a mouthful, but basically it's that idea that you're advocating for something, you're supporting something very outright about it. So you can think of advocacy as being something that is really small. So, for example, your parent might advocate for you in terms of school. Maybe they're advocating for free tutoring or something like that. And then advocacy can take place on a far greater scale as well. There can be advocacy groups, different corporations, and just organizations in general can form together to create these advocacy groups. And there's lots of just individuals as well who form groups to support different causes. And oftentimes we also see groups like this forming to be a voice, I suppose, for people who don't have one, or for people who are less kind of powerful. So, for example, when we think about things like refugees and that kind of thing, we have different advocacy groups who try to support people who are wanting to get entry into a country, to get their visas sorted out, that kind of thing. Okay, so law reform. Now, this is kind of a three-step or three branches, I suppose. So it can be changing existing laws, it can be repealing existing laws, so removing them entirely, or it could be just creating new laws as well. So when we think about the kind of formal definition, it's the process of examining existing laws and advocating and implementing changes in a legal system. So the aim is usually enhancing justice or efficiency. So it can be because society's beliefs or values have changed, or there's some kind of inequity in the existing laws, so they need to be changed or repealed. And you could also have new laws entirely because there are new factors that come about as time goes on. So technology is a really clear kind of example of that. And that can result in new laws being necessary. So the modernization of the law by bringing it into accord with current conditions, getting rid of any defects, simplifying it as well, and the adoption of new or more effective methods for the administration of the law as well. So there's lots of different aspects to that. It's not just about changing things, it can be about new things entirely, but the overall aim is improvement in general. So an example of law reform is when we think about 2022, there was the data breaches. So we had Optus and Medibank both had the data breaches, and there was actually law reform, I suppose, after that, because we had some new legislation that came through about data. So it was making it so big companies had more of a responsibility to make sure that any data that they do collect is protected well. So that is an example of how, I guess, technology and what people are able to do in terms of hacking or sort of invading the sort of systems of big companies like that have lots of data, that has resulted in those laws being necessary. Now, lobby. So, according to the Lobbying Code of Conduct, lobbying activities are communications with the Australian government representatives in an effort to influence federal government decision making. So, if you're lobbying the government, you're trying to get them to be aligned with what you want and your values. You're trying to influence their decisions in some way. So you could be looking at getting a government contract or a grant. You could be looking at the way they allocate funding or the way that they're amending legislation. It could be a government policy or program. Any of those sorts of things that are of interest to a lobby group, they can try and influence the government's movements around those things. So a lobby group is an organized group or association that attempts to influence those legislators to achieve that desired outcome. And there are two different types of lobby groups. You've got sectional lobby groups. So that's a self-interest lobby group like a trade union. And promotional lobby groups. So an organized group promoting a particular cause. And like advocacy, it's pretty closely related to that, but it's more about government decision making, because you can have direct and indirect lobbying. You could be sending letters or having meetings with the actual members of government, whether it's the local level, state level, or the federal level. Or it could be more indirect kind of lobbying where you are trying to bring awareness in general to other people, maybe not communicating directly with the members, but maybe their staff or something that's slightly more indirect like that. Utilitarianism. So, this is a system of thought that states that the best action or decision in any particular situation is the one that brings the most advantages to the most people. So, the most benefits, I suppose. And an example of how this can go wrong is the 2009 home insulation program from the Labor government. So this definitely had this idea of wanting to bring the most benefits to the most amount of people, but it wasn't executed in a way that worked, unfortunately. So in 2009, the government announced this program, which was it was aiming to stimulate jobs growth and encourage homeowners to reduce their energy consumption. And so homeowners were able to receive funding to have this insulation installed. But because inexperienced workers were managing the process, there was a few deaths. So 4 installers died because they were electrocuted. And this actually resulted in a royal commission as well. And so it had good intentions where it was supposed to be stimulating jobs and helping with that sort of sustainability aspect with energy consumption. And sometimes it's pretty hard to get both of those things. So this was bringing lots of advantages to lots of people, but unfortunately it did negatively impact some people. Now, throughout today's lecture, we've got some questions to get you thinking about what we've discussed and to act as a little bit of revision for you. So as we said earlier, the unit that we're talking about today, you'll be doing an assignment for. So you won't be needing to memorize things for an exam, but you can still have this idea as kind of something to revise. You still need to understand these things. So the questions that I've got throughout this slide deck will hopefully help with that revision. You can go through it later and try and see if you can answer these different questions without looking at all of the resources. And I encourage you as well to pause the video as well and see if you can answer these things before you move on to the rest. So the first one is describe law reform. And something that can be handy when you're thinking about these things is try to think of an example as well. So it can be tricky to remember lots and lots of different concepts when it's just a whole bunch of words that are perhaps not familiar to you, lots of different terminology. But if you try and remember real world examples that we talk about today or that you can think of yourself, that can help you remember the different concepts that you may otherwise not be able to keep in your mind. So, for example, that one we just spoke about with the home installation program may help you remember utilitarianism. Okay, next up is terms of reference. So the scope and powers of an inquiry. It's just laying out what is going to be investigated as part of this investigation. So in terms of Royal Commissions of Inquiry, we've got a process with 8 different steps here. So first of all, the government is going to request the Royal Commission into a certain topic. Then they go and decide what the terms of reference will be. We've got a commissioner being appointed as the chair. Others can be appointed to work with the commissioner. Then you've got a whole bunch of evidence gathering, so witnesses are heard, and then the findings are decided, recommendations are made, and the report is created and given to the government. So to start with, it's very early on in the piece that those terms of reference are laid out, because then that informs the rest of the process. So because it's determining what the scope and the powers of the inquiry are, it's going to determine who is, what kind of evidence they want to gather, what kind of people they may approach to try and get some evidence, and also the kind of commissioners or the kind of people that they get involved in the process, depending on the sort of topic that they have chosen as their inquiry topic. So here is an example of all of those steps laid out with an example alongside it. So in 2012, the Gillard Labor government announced a Royal Commission after public pressure and allegations of a police officer in New South Wales. So this Royal Commission was into institutional responses to child sexual abuse. So you can see how we've got the government calling that inquiry, and the next step was them determining those terms of reference. So in this case, they wanted to inquire into and report upon responses by institutions to instances and allegations of child sexual abuse in Australia. So you can see how the kind of wording in that is giving us that scope to go by. So it's responses by institutions. So that's sort of narrowing down the focus. Allegations of child sexual abuse is narrowing it further, and then also, of course, specific to Australia as well. Then you've got different commissioners being appointed. You've got a whole bunch of witnesses being heard. So the terms of reference also influenced this. So witnesses reported on events that occurred in Scouts Australia and lots of different other organizations that knew about this area. And then you had lots of recommendations, 409, and then the final report being presented at the end in 2017. You can see how it's a really long process over more than 5 years in this case. Now, consultations. So the Australian Law Reform Commission conducts research and consultations with stakeholders. And by talking and listening to people, it can understand different views and experiences of the law. So, of course, everyone has different experiences, different opinions. So, commissions like this need to seek a whole bunch of different information so they can actually understand those things, because they otherwise wouldn't be able to. So they want to consult with people not only who have expertise in the laws under review, so maybe they've got some kind of law background, or they know about the laws on some kind of level, but it might just also be that experience with the laws. So maybe they've been negatively or positively impacted by the laws. Maybe they think the laws are discriminating against them or something like that. And it's also about people who are likely to be affected by the laws. So maybe they haven't been affected yet, but understanding what their experience would be if it were to impact them can also be helpful in these cases. So you can have a whole range of inquiry stakeholders, so government departments, courts, legal professionals, industry groups, and special interest groups, academics, and then other members of the community as well. Issues papers. So these are papers that are presented to an inquiry that detail the issues under investigation. So as part of these inquiries, lots of information is sought, and issues papers are providing some of that information as well to inform that inquiry. So they can provide information, data, and further explanations that would assist the inquiry and the reporting process. So you can see an example here on the screen with the Native Title Act, and you've got an issues paper on that. So the Indigenous Justice Clearinghouse, or the IJC, publishes issues papers and advocates for law reform on Indigenous justice matters. Now, this is an example of advocacy. They've got the kind of interest that they are wanting to support and advocate for, and they have that means of doing that. Their means is to create these issues papers. So submissions. Now, we've been talking a lot about how the Royal Commissions are going to seek a whole bunch of information, and one way that they can get information is through submissions. So any kind of public contribution to an inquiry. Now, anyone can make a submission. It's an open kind of system. And as part of an inquiry, a committee usually asks for written submissions addressing the terms of reference. So again, that idea of terms of reference, it obviously needs to be relevant. So those terms of reference are really important to show what they're actually looking for and make sure that they get the evidence that is actually going to support their decision making. Now, submissions are actively sought by the Australian Law Reform Commission from a really diverse sample of the community, as well as those with that certain special interest in the inquiry. And so submissions are really important because otherwise the government the Law Reform Commission is not going to know everyone's experiences. You need that diversity. Otherwise, it's not going to result in the fairest possible outcome for everyone. Now, next up, we're looking at the impetus for law reform. So this means the sort of reasoning that could result in law reform. So what is the sort of trigger, the prompt behind laws being changed or being introduced entirely or being removed entirely? So changing values, needs, morality, and ethics. So a significant challenge, I suppose, for the legal system is how to keep pace with the changing needs of society so the laws remain relevant. As time goes on, lots and lots of things change, so the laws have to change to reflect that, but that can be tricky to do. And so the law must be representative of society's values and it must adapt as those change. And there's actually also new forms of criminal activity, new technologies that facilitate that kind of criminal activity, and that can result in new laws being necessary as well. So, for example, if we think about artificial intelligence as a very current kind of example, there are people out there who want new laws around this kind of thing because of concerns over things like plagiarism. So, we know that the artificial intelligence systems are trained on other people's creations or other people's sort of information, that kind of thing. So it could be paintings if we're thinking about, or illustrations or pictures of any sort. When we think about the AI that generates images, and it can be books or research or anything like that for AI that generates text. It all has to be trained on something, and there are people out there who think new laws need to come into play so their intellectual property is protected. Now, that is an example of how technology can really play a part in the need for law reform. Now, laws can change on an ongoing basis in response to political pressure as well from lobby and advocacy groups. That is one of the aims of lobby groups, as we saw earlier. They want to influence decision making. So it's not just about new technologies, new criminal activity. It can be about things that have been a problem for a long time, but the lobby groups are finally getting through to the government and making that impact with those decision makers. So there are a bunch of law reform influences, and we've got 5 that we're talking about today. So social influence. So that is pretty straightforward with society's values. You can probably tie every kind of example you can think of for an impetus for law reform. You can probably tie to society's values. We'll have a look at some examples shortly that will help illustrate that for you. Cultural influence. So we're in a multicultural society. There are lots of different backgrounds and beliefs and things like that to cater for and to recognize those that diversity and those differences, you may need to make law reform, make changes for the law. Moral influence. So this is about what we believe is right or wrong. Political influence. So the federal, state, and local government can all influence the laws passed. And economic influence. So this can be in response to economic circumstances. So we know that interest rates and inflation and things like that are really big at the moment with cost of living. It can also be laws that impact society economically. So the laws in response to economic circumstances, that is kind of a reactive thing. And it can also be, I guess, proactive as well. Lobby groups can consist of large multinational companies. So you've got this economic idea is really important to some groups who want law reform because they are in that business of needing to make profit. So let's have a look at a few examples from these different categories. First up, we've got equal pay for equal work, which in this case we could list as a social example. And so in 1972, the Australian Conciliation and Arbitration Commission granted women equal pay for work of equal value to men. So previously it was only when women did the exact same work as men, rather than what was considered equal value. So this was in response to lobbying from unions and the newly elected Labor government as well. And another example, the same-sex marriage legislation that changed back in 2017. So the Australian Parliament passed the Marriage Amendment Act, and that was after a survey showed that 60% of Australians supported the law reform. Now we can see how things overlap. So we looked at those different impetuses for law reform, and we said social was one that tends to apply to all sorts of different examples you can think of. And there's also overlap as well. So you could say that the politics made an impact in both this example and the previous one with equal pay for equal work. You had lobbying from the government. In this case, you had the government holding the survey. So those things impact this law reform as well. Now, a couple of different examples. We've got an economic one from the United States. So the Inflation Reduction Act 2022 was passed by the United States Congress to decrease inflation. So it lowers drug, healthcare, and energy costs and makes wealthy individuals and large corporations pay their fair share of tax. So that is something that's happened with law reform that was as a result of that economic kind of situation with wanting to decrease inflation. A moral example. So voluntary assisted dying is something that is a gray area when it comes to whether it's right or wrong. You've got different opinions about that based on beliefs, whether it's religious or political or otherwise. So Queensland passed the Voluntary Assisted Dying Bill in 2021, and those laws came into effect in 2023. So Queenslanders who are already dying now have the option to die on their terms, and it's a moral issue because whether this voluntary assisted dying should be legalized is something that's contentious, because some people believe it's right, that people should have that choice, and some people believe that that's morally wrong. Okay, so the influence of lobby and advocacy groups and the media. So, as we mentioned, a lobby group is that group that is organized together and it's attempting to influence the government to achieve a desired outcome. So, special interest groups can include school associations, conservation groups, trade unions, business organizations, and political parties. So, you've got a whole huge range there. And Australians have the right to discuss an issue or lobby their elected representatives at all three levels of government. So this means that we have the right to approach our local government member, our state government member, or our federal government member, or any other member for that matter, to try and get our voice heard with whatever we want to bring to their attention. But when this is organized collectively, so instead of you just going individually to that government member, when it's organized collectively, that special interest group is becoming a lobby group. And this is bringing more power to that group. If they're banding together to create a lobby group, then that's going to put more pressure on decision makers because you've got more people power behind it, more voters who are showing what their beliefs are, more sort of power with I guess the majority of people. And lobby groups and the media can influence public opinion on topics, and that can lead to change in societal views. So, something that we often hear about when it comes to the media is like agenda setting and framing. So they put things on the agenda. The media is reporting on certain things to get them into the public eye, into our minds, and so we're paying attention to them, and they frame those things in certain ways to shape our views on them. So those views can then form how we decide to vote, what we lobby for, what we believe, and then of course it all just keeps going down this system where that then can result in law reform. So an example is double jeopardy. So this is a defense that prevents someone who's been accused from being tried again on the same charges if they've already been acquitted or convicted. So in 2014, victim lobby groups successfully pressured the Queensland government to overhaul Queensland's double jeopardy laws in the wake of R.V. Carroll. So that was 41 years earlier. And so Queensland's laws changed so that someone who was previously found not guilty could be retried for that same crime if new evidence was found. So this was something that was deemed important because we've spoken a bit about this idea of technological kind of changes. So as the Attorney General at the time pointed out, advances in technology, particularly things like DNA testing, means that new evidence may become available years after a trial. And so it would be an injustice if that was just ignored. And that was why these laws were changed. So someone could be retried if new evidence is found. Now, there is a movie called Double Jeopardy as well that you can see on the screen. And I believe that that was based on this opposite idea where if you've already been convicted for something, then you can't be convicted again for the same crime. So Queensland went against that idea because this recognition that new evidence can be found, which can change what the result is, what the findings are. Another impetus for law reform is patterns of crimes and civil offences. So people expect that the government is going to maintain law and order. And in order to do that, one of the things they need to do is identify patterns of crime. And that is going to allow them to make laws, amend laws, and potentially repeal laws to make sure that they have things in place to cater to those changing patterns of crime. So there could be new harms, or existing harms could be getting worse, and they need to try to stop those things from happening. Now, there are a range of different strategies, and it can involve individuals, communities, businesses, non-government organizations, and all levels of government as well. And it can be influenced by an understanding of local crime and crime patterns. So, key areas of law reform in Australia in recent years, things like domestic and family violence, medical negligence, juvenile crime, and alcohol-fueled violence. Technological advances, we've spoken about a lot already. So this can include technological advances that assist in the investigative process. So, of course, technology can be useful. Like we saw that DNA idea where new technology can result in evidence being found in helping with that investigative kind of process. But it can also facilitate criminal activity. So you've got two different sides here with one that's positive and one that's negative. So the law needs to be updated to minimize the opportunity for individuals to be exploited or harmed by technology. So an example of how technology can facilitate criminal activity, if we think about something like cyber stalking. Now, this has been something that's been, I guess, a thing for a long time, but or stalking, in fact, has been something that's been around for a long time because people could do that. It was a physical kind of thing that people could do in person. But then cyber stalking has meant that idea of stalking has taken on lots of new forms. So you can have email, cyber stalking, internet, computer, lots of different devices and platforms that we have that can be used for that instead of just that physical idea that it used to be. Okay, another question for you to have a look at. So 5 factors influence law reform. We looked at the start when we were talking about the impetus for law reform. Now, one of them was social influence, which has impacted same-sex marriage and equal pay for equal work. So choose one of the other 4 factors influencing law reform, explain the factor, and provide a real-world example of how the factor has influenced law reform, and it can be domestic or international. So remember, we looked at the idea of the American legislation that they introduced for inflation, and we looked at the voluntary assisted dying laws in Queensland. So if you can, try and think of something different that you may be aware of that relates to one of those other 4 factors aside from the social influence. Okay, continuing on with our impetus for law reform, we've also got increased transnational and organized crime. So what are these? So transnational crime is all serious criminal actions that involve more than one country, and that involvement can be through the planning of those criminal actions, the actual execution, or just the impact. So we probably think of execution the most, so involved in that sense where they're actually carrying out those criminal actions, but it could just be the pre kind of phase where they're just planning it, or it could just be the impact that results. And organized crime, so criminal actions that powerful groups are going to plan, control, and execute on a large scale. So lots of criminal activities are not limited to borders of a country or different states or towns. So often international crime organizations are going to operate for some kind of monetary gain, but some can be politically or religiously motivated as well. And we sometimes term those terrorist organizations. And Australia collaborates with international agencies to try and work against transnational and organized crime. So if we have a look at an example as well, so we know that recent technological developments have resulted in new kind of patterns of crime and new crimes in general. So with the internet and the ease that people can now move between countries because of different sort of travel advancements that we've had, there has been an increase in transnational and organized crime. So pirates' ability to access modern equipment like powerboats and different weapons has caused an increase in piracy. Now, an example of a movie that you may be familiar with is Captain Phillips, that has Tom Hanks in it. And this explored this idea of piracy where you've got a ship that is traveling between countries with cargo, and it's been intercepted by pirates who are wanting to get money, and they hold the crew hostage in their attempt to do that. So this is showing this idea of between different countries. So it involved America, but it also involved, I believe, Somalia was the country where the pirates in this movie were from. So that idea of it involving multiple countries. Now, significant events and current issues, of course, are going to result in changes to the law in many cases. So they can highlight a law that's not working well, or they can highlight the need for a new law entirely. And a couple of examples that many of us will be familiar with are the Port Arthur massacre in 1996. So this caused a major shift in people's opinions around gun control. So that then resulted in law reform, and all Australian states and territories banned automatic and semi-automatic rifles. And another example, the September 11 terrorist attacks in the US in 2001. So before this event, Australia had no counterterrorism laws, but since then, more than 92 laws have been introduced. So a significant event can result in lots of different law reform to try and prevent those events from happening again. Okay, moving on now to the role of the law reform commissions. So they investigate and provide law reform recommendations on matters that the Australian Attorney General refers to it. So it's an independent Australian government agency. And state or federal government can initiate a royal commission on any matter connected with the public, with peace, order, and good government of the Commonwealth, or any public purpose of any power of the Commonwealth. A bit of a mouthful. But usually royal commissions are called when there are reports of an illegal activity or a gross administrative inability in an area of Australian life. So we've had things in the past, like, for example, the nursing home situation where there were reports of lots of different problems and mistreatment in nursing homes, and then as a result, a royal commission was held. So there are some strengths and limitations when it comes to law reform and royal commissions. So royal commissions are independent from the government, and so they are therefore free of that kind of political bias in a sense. But it is at the same time the Parliament's choice whether they implement the recommendations, and it's actually the government's choice whether the commission is initiated to begin with. So it's unlikely that one is going to happen if it's against the interests of the government. So if it does happen, then that's great, because you do have that sense of independence and freedom from bias. But then the actual initiation can be problematic, and then implementing any recommendations can be problematic, because that can be influenced by those government kind of motivations and opinions. They are really thorough. So we saw earlier with that example that it took more than 5 years. So they are very thorough and take in a really wide range of sources and opinions to make those recommendations. But then with that, of course, it is very expensive, very time consuming, and that limits the amount that can take place. You can't have just a royal commission into anything and everything, because that's just not feasible from that resource point of view. And if the recommendations of a royal commission are implemented into the law, the laws will be that effective representative kind of thing of the opinion of the people. So you've got some strengths and weaknesses that kind of show the limitations, but then the benefits as well of royal commissions. So let's have a look at an example of a royal commission. So a royal commission into the child protection and youth detention systems of the government of the Northern Territory was called in 2016 by the federal government. And the reason for this was actually the media. So we saw earlier that one of the impetuses for law reform was the media. So in this case, an episode of the ABC's Four Corners aired, and this showed footage of corrections officers who were mistreating the young people in detention, and that triggered this call for this royal commission. And the purpose was to inquire into the treatment of children in detention centres and to make recommendations about legal and cultural reforms to prevent that kind of treatment and improve the overall child protection system. So you can see here Dondale Youth Detention Centre, which was a big focus with this situation. And the final report in this case included 147 findings, 227 recommendations. And so some of the recommendations in this case were the responsibilities of the territory. So it can be the state or territory that needs to implement changes, and it can be some that relate to the Commonwealth. In this case, 29 were related to the Commonwealth, and the Commonwealth is that federal level with all of Australia. And you can see in this case, the Commonwealth responded to 26 of the 29 recommendations. So it resulted in pretty big changes, and it did respond to most of those recommendations. Okay, we've gone through lots of kind of prompts that can result in law reform. So the impetuses for law reform. And so try and explain two, and remember the idea of giving examples and how that can be effective when you're explaining anything. Examples are always handy. The role of parliamentary inquiries. So parliamentary inquiries do share lots of similarities with royal commissions, but parliamentary inquiries investigate a particular policy, while royal commissions are investigating that kind of area of interest in society. So a parliamentary inquiry is led by any member of parliament with no subject matter expertise necessary. And then royal commissions, on the other hand, are led by a panel of experts and a retired judge. So you've got slightly different areas of focus with what they look at, and then slightly different in terms of who is doing that investigation. But they do have those similarities as well. They both, of course, report back to the government with recommendations, and they both operate at a federal, state, and territory level. So you can have parliamentary inquiries and royal commissions at all of those levels. Okay, so parliamentary inquiries, if we look a bit further into these, they are conducted by committees that have those members of parliament into various contemporary issues, and then they report back to the parliament. And the purpose is to investigate and make recommendations that may translate into law reform. And they are given to the Senate and the House of Representatives, and they must be responded to within 6 months. So the Federal Senate has a comprehensive number of select or standing committees of inquiry. So what are these? So a select committee is appointed by the Senate to conduct an inquiry into a specific matter, and they have to report back in a particular time frame. That is also part of those terms of reference we spoke about earlier with the scope and what is to be investigated. And then once a select committee has completed its work, it is disbanded. So it doesn't exist any longer. So I suppose you can remember this by thinking select. They've been selected for this particular thing, and so it does kind of sound one-off with that wording. A standing committee, though, is a permanent committee that stands or remains for the term of the parliament, and it can be classified into 3 categories. You can have domestic committees, legislative scrutiny committees, and legislative and general purpose committees. So some recent focuses of parliamentary inquiries include the NDIS, so the National Disability Insurance Scheme, aged care, climate change, social services, and of course, cost of living. And you can see here in this little image that you go from launch, where you announce an inquiry and call for submissions, Then you've got the evidence gathering, where you'll receive and consider submissions and any evidence that's gathered. You have the report drafting stage, and then the presentation stage, where that report is finalized and submitted. Describe at least one strength and one weakness of royal commissions. So remember, we looked at earlier in that table, considering things like the time and the cost, who's involved in initiating and conducting the royal commissions, and who's involved in the recommendation side of things as well. Those are all considerations when you're thinking about strengths and weaknesses. Next up is the role of coronial inquests. So this is yet another way that the law reform can occur in Australia. So it is a public hearing or an autopsy into the deaths of a person or more than one person. It's conducted by the coroner, and it's held to determine the medical cause of a person's death. So this is different to a trial, a criminal kind of trial, because the purpose here is not to determine who was responsible, but simply just to determine what actually happened. They want to know how the person died, what were the sequence of events that caused that to happen. Now, each jurisdiction has a coroner that can conduct an inquest into the death of people or one person. And it's often when it was suspected to be caused by an unlawful act, or if some kind of tragic event has occurred as well. So you don't have a coronial inquest when someone dies naturally of old age, but if it's suspicious or as a result of a tragic event, then a coronial inquest would potentially occur. So it can influence law reform in two ways. It can highlight an injustice in the current law, and it can also highlight injustice in the criminal investigation process by determining the causes of deaths in custody. So if we look at things like people being mistreated in detention or in prison, then that could result in law reform, because they would be recognizing that there are issues to address in that area. So the coroner may make recommendations to the Commissioner of Corrective Services in that case. So depending on the nature of the inquest, the coroner might recommend to the government an action or a series of actions, and this can include law reform. And the idea behind this is to prevent or minimize a repeat of any of those events or the criminal offences that resulted in the death or deaths. So the coroner controls and coordinates each step of the investigation with the police, and they have a wide range of powers. So they're able to request additional reports and statements or information about the deaths or death. And they can also obtain more information from investigators, police, doctors, all the different people who may be involved or may be experts in some way that is helpful to understand the situation. So inquests are usually conducted in the magistrate's court by the coroner for the purpose of gathering information and facts about what likely caused the death and whether any negligence was involved or any law has been broken. So an example is Gabe Watson. So Tina Watson was an American woman who died in 2003 while scuba diving in Queensland during her honeymoon with her husband, Gabe Watson. So he was initially charged by Queensland authorities, and a coronial inquest was called because certain parts of the story didn't add up with what caused her death. And during the inquest, it was found that Gabe's story contradicted some evidence that was collected from the dive computer and from witnesses. So it was found that he abandoned her while she was experiencing distress during a dive, and he ended up being convicted of manslaughter, and he served some time in an Ipswich prison. So you can see here the role of people with technology for one, and then just submissions from witnesses. So Tina's death was actually accidentally recorded by a fellow diver who had a camera underwater, and you can see that it captured some evidence that was used as part of this inquest. The role of a specialist task force, if we look at that in comparison with parliamentary committees. So a specialist task force is similar to a parliamentary committee because they are both inquiring into a specific issue. They're both reporting back to the government, and they both operate at those different levels with federal, state, and territory. So while they have those same kind of functions, it's about who is doing it that is different. So a specialist task force, as the name suggests, it's conducted by specialists in the field of inquiry, whereas, as we looked at earlier, parliamentary committees are about members of parliament. So that's what they consist of. So an example of work that was done by a specialist task force. In 2015, we had a report called Not Now, Not Ever. It was about domestic and family violence in Queensland. So the task force was requested to examine Queensland's domestic and family violence support systems and make some recommendations on how the system could be improved and how to prevent domestic violence. So they presented 140 recommendations, and a majority of those were implemented. And so this, you can see how it works on that state level as well. Okay, describe coronial inquests and how they are different to trials. The role of the Australian Institute of Criminology. So this organisation conducts criminological research, conferences and seminars, and it also publishes its findings and makes recommendations to the government. So its role in law reform is to investigate patterns of crime and identify areas in the law that need to be reformed. So the AIC has been responsible for significant law reform at all the different levels, federal, state, and territory. So for example, it's important that you've got some consistency in the law. So they have actually brokered some national agreements so that all states and territories have the same way of dealing with a particular matter. It wouldn't make much sense if they were different for different states and territories. They've also identified loopholes in the laws to eliminate variations in legislation and inconsistencies between the same laws in all government jurisdictions. they've recommended specific legislative changes. So new offences, increasing penalties and fines, those sorts of things. And they've undertook different evidence-based research to inform policy and practice as well. Okay, describe the similarities and differences between parliamentary committees and specialist task forces. So in this case, you've got similarities in terms of what they are doing, what their objective is, their purpose is, but differences in terms of who is involved in each of these. Parliamentary committees involve members of parliament, and specialist task forces involve specialists in the field of inquiry. Okay, so some challenges to law reform. So there's all of these different ways that we've spoken about that law reform can come about, all of these ways that things can be investigated and things like that. But there are, of course, challenges that can make it all quite tricky. So one of them is social divisions. So often the parliament is unwilling to legislate in areas that may be contentious or divide public opinion, which also does sort of intersect with this idea of politics. They want to keep voters on side, and they don't want to make decisions that are really contentious in order to potentially jeopardize their sort of standing in that political sense. So, for example, euthanasia and abortion are issues that aren't morally straightforward. There's different opinions on whether they're right or wrong. We looked at earlier that voluntary assisted dying legislation in Queensland. So it's difficult to legislate those sorts of things because people's morals are influenced by lots of factors, like their religion, their personal experiences, and so there's no clear right or wrong, and it can therefore be difficult to legislate those sorts of things. Now, budgetary constraints can also be a challenge. So their ability to legislate can be limited by what their budget is, and if they only have a certain amount of money, then they may be forced to prioritize certain things over other things because of not having the means financially to do something about the other problems. Political pressures. So I mentioned earlier, politics does intersect with the social divisions idea, but political pressures can influence the parliament's ability to pass legislation. You've got to have the different voting systems in the government where you've got to have a majority in favour. So especially if the existing government is hostile to whatever the change is, that can make it really tricky. And this can also be a budgetary constraint as well. So if the Senate refuses to pass the government's legislation on finance, that can threaten the survival of the government. The nanny state. So this is something that you can think of what a nanny is. We might not really refer to people as a nanny anymore, but someone who is taking care of a child, maybe when their parents are at work. So the nanny state is a political concept, and it's implying that government policies are overprotective or interfere with personal freedoms. And if laws are perceived to be too controlling, they might not be as effective, and that can challenge the Parliament's ability to legislate. And lastly, Parliament's limitations. So law reform can be hindered if the idea being reformed is established in the Constitution and is thus beyond the reach of Parliament. So this is why having a referendum and passing a referendum is such a big deal, because it's something that can't just be changed. So different legislation can be changed if a new government comes in and they disagree with something a previous government did. That happens often with the government, but a constitutional change can't happen like that. You've got to hold a referendum, like we've recently had with the voice referendum. And as we know, it is notoriously difficult to get referendums passed. You've got to have the majority of states and all of those different requirements there. And so the Constitution does limit what the Parliament can do, since it is so powerful like that. Okay, explain the role of law reform bodies and commissions and how they influence the law reform process in a dynamic Australian society. Okay, we've finished the content aspect of today, and we're now looking at your inquiry report assignment, so IA2. Now, this involves you researching a current legal issue, and you need to collect, analyze, and synthesize primary and secondary information, data, and sources. So the issue must be an area of law that requires reform. So it's a current issue that requires law reform, change, or a new legislative instrument. And it must refer to the Australian or Queensland jurisdiction. It can't be something entirely unrelated to Australia. So an inquiry report uses research to assess a range of cognitions in a particular context. So you've got to be able to locate and use information beyond your own knowledge and beyond the information you have been given. This idea of inquiry, we've looked at all of these different types of inquiries today, and we've spoken about how they have lots of submissions, they have lots of evidence gathering processes. So this is where you need to be doing that yourself in order to find information to include in your report. Now, there is a bunch of terminology that will be used in your criteria and your task sheet for this assignment. So we're going to go through a few of these things to clarify anything you may not already know. Now, something that always comes up in legal studies is this idea of nature and scope. So nature is the essence and elements of the legal issue being considered, and the scope is the extent of the components of the legal issue. So how wide it is. So we'll have a look soon at what you can be including in each aspect of your report, and nature and scope is one of those aspects you'll need to cover. A stakeholder, so a person, a group, or an organization that is affected by, can affect, or is concerned with an issue. Stakeholder perspectives are, of course, the beliefs and opinions of those people in regards to that particular situation. You need to decide, so you need to reach a resolution as a result of your research and your analysis. So you'll be presenting some alternatives in this assignment, and you need to make a decision about which one is best. Recommendations, so courses of action that you think are most suitable for the situation. implications. So what are the effects, results, or consequences that might happen in future? So this is an implied thing. So think of implications. It sounds like implied. So this is you analyzing and evaluating and think what could be the results or the consequences. It's not necessarily definitive. It's not definitely going to happen. And a few more. So a concept is just a legal idea. Principles. So in legal studies, these are guiding intentions that underline the legal system. So this is something that you may not really understand, but you'll be thinking about things like the rule of law, equity and fairness, the presumption of innocence, the right to access the law and have legal representation, the right to a fair trial, all of those things that underpin this idea of what constitutes a good legal system. Process is a system for conducting activities. Now, primary and secondary sources. It's important that you have both in this assignment. Now, secondary sources are always easier to get because it's data not generated or directly created by the author of a source. So you can be looking at case law, legal databases, legislation, different websites and media and expert commentaries. Whereas primary, on the other hand, is information directly by a student. So doing a survey or getting information directly from a source in some way. So, explain 2 challenges to law reform in Australia. We looked at that list before. For these questions, again, I encourage you to pause the video and try to write some paragraph responses to see what you can remember. And then, of course, use all of the slides that we've got that you'll be able to access after today's session and use them as a sort of study guide to make sure that you're on track with remembering everything that you will have learnt at school and throughout today's lecture. So the structure of an inquiry report. Now, this is something that's often tricky for students, is wondering how to structure a report. Now, it can vary depending on what your issue is and what sort of requirements your school or your teacher may have. But this is a general structure that is pretty good for most cases. So, of course, you're going to have some kind of introduction. Then you are probably going to want to outline the nature and scope of the legal issue that you have chosen. You'll look at stakeholder perspectives. Now, there can be a couple of structures here. You could have 2 subheadings, one for each of your 2 stakeholder viewpoints. So you'll be needing to look at 2 stakeholders in particular. Or you could have 2 subheadings. The first one could provide an overview of all of the affected stakeholders, and another could then summarize your 2 chosen stakeholders and their viewpoints. Next, you'll have your legal alternatives to reform the law. So you will have already now assessed the situation and its scope. You will have considered the stakeholders and their positions, and you'll now be presenting those possible solutions to reform the law. You could have 2 subheadings here, one for each of your 2 legal alternatives. That would make sense structurally. And then, of course, you'll have your recommendations. In this section, you want to state your decision, followed by your recommendations and your reasoning for the recommendations. The reasoning is really important, so make sure you don't skip that aspect. Then you'll have your conclusion and your reference list. Okay, so how to approach those different report sections. So for nature and scope, you want to include how the legal issue is seen or legislated in different countries. So while you will be focusing on something relevant to Australia or Queensland specifically, you can think of nature and scope on that global kind of scale. You'll also want to state the domestic legislation which can influence the legal issue. And you could also find international legislation on your legal issue as well to show that comparison between Australia and other countries. In terms of your decision really needs to be clear. So it can be really tempting to be a fence sitter where you sort of say that both of them are pretty good, both of them have pros and cons, and you don't make it clear what you're suggesting should be done. But it's best if you do. So you could argue, for example, although stakeholder 1 raises some good points, stakeholder 2 is more disadvantaged by the current laws, and therefore this particular thing is best, this law reform alternative. Or you could be focusing on the legal alternatives, saying legal alternative 1 would be effective in the short term, but legal alternative 2 would solve the legal issue without any possible reoccurrence, and therefore alternative 2 is best. So making sure that you justify your decision using that legal criteria that I mentioned earlier. So the rule of law, just and equitable outcomes, protecting human rights, all of those different things that are those principles the law is meant to be aligned with. In your recommendations, make sure you are detailed. So if your recommendation is to change the law, then what law are you changing? What are you changing it to? Why are you changing it? And how easy or difficult will changing it be? So don't just say something really generic. You need to think about all of the considerations that would go into what you're suggesting. And ensure your recommendation is a legal recommendation as well. So, for example, assigning organizations to teach children about cybercrime can be an effective recommendation, but it's not a legal one because it's not legally binding. So, legal recommendations could be passing a bill, having some kind of act or some kind of charter or a referendum. Those things are legally binding. Implications. So think about whether your recommendation will make a change and what the impact will be. So it may promote more protection of human rights in Australia, for example. And think about the practical implications of the decision to make sure that you're demonstrating that higher level thinking. Okay, question 9. Explain what nature and scope mean in the context of legal studies. And also try and think about what we looked at just a few slides ago, thinking about what you would include in a section of this report dedicated to nature and scope. Okay, so now we're on to looking at an example inquiry report. So one of the things that you hopefully can master pretty easily for this is the formatting. So one of the things that you'll be assessed on is your ability to create a response, which is assessment objective 5. Now this says that the features of the report are the report genre are consistently demonstrated with a cover and contents page, headings, and subheadings. So, of course, there are other aspects too in terms of this creating a response thing, but this is something that you can hopefully get pretty easily. So some cover page inclusions, you've got your the type of the report, so inquiry report in this case. You've got the title, mine was called Press Freedom in Australia. You've got the purpose of the report. This is similar to the introduction with outlining what it is about. You've got the word count range, and you've got the date as well. Now, zooming in on the table of contents, you'll see that this is really similar to that structure that I outlined earlier. In my case, I had subheadings underneath that nature and scope idea because there are multiple aspects to explore. So dividing those up into logical sections is always handy to make it more readable. In terms of the stakeholder perceptions aspect, I chose to go with the alternative where I speak about all of the stakeholders to begin with, the ones that are affected, and then I zoom in on two and look at their viewpoints specifically. In terms of legal alternatives, I've got those two headings with what the alternatives are, and then my recommendations, my conclusion, and my reference list. So if you're working in Word or Google Docs, no matter what kind of application you're using, make sure that you use your headings, so your heading 1, heading 2, etc., and that can help you then generate your table of contents. So we'll now go through and have a look at a copy of the different paragraphs that I had as part of my report, and I encourage you to have a look at this in more detail in your own time to read it in full. And keep in mind that this is going to be different to what you'll be doing. This was years ago now for me, so your report will not be on the same thing more than likely, but it can give you an indication of how you can structure and approach yours. So in this introduction, I have outlined what press freedom actually is. That is the topic of my report. And then I clearly state what the report will do. So it's going to examine the nature and scope of the legal issue of press freedom in Australia. And it's going to discuss recent legislative changes, stakeholder perceptions, legal alternatives, and a final recommendation is provided. Okay, so in nature and scope, the first section is press freedom. So I outline an example to start with. So I'm looking at Annika Smethurst and how she had her home invaded or raided because of this idea of she reported on something that that they were concerned about national security, so they wanted to find out where she got her information from. You can see at the end here of this paragraph, I've got my sources in brackets, and you can have a superscript at the end of a sentence, and you can see what that looks like. It's like a little flying kind of number. If you're having if you think of maths where you've got a number that's squared or cubed, it's that kind of floating number. And a superscript is a footnote, which is at the end of your report. It appears, or an end note appears at the end of the report, and a footnote appears at the foot or the bottom of each page. And it contains some more information. So in this case, my footnote said, for such actions, Miss Smethurst could face prosecution under Section 79 of the Crimes Act 1914. So I was also adding more relevant information about the nature and scope of the current laws and the current situation. So I've provided that example, and I wanted to provide a little bit of extra information about how those current laws apply to that example that I've given. Here I provide more examples. So there, as I said in that earlier introduction, there had been lots of examples of things related to press freedom in that year in 2019. So I've provided some more examples here. And I've also looked at something related, I suppose, to overseas with this idea of Mimi Mifo and her visa being denied because of them not being satisfied that her employment and financial situation provide an incentive to return to Australia. So continuing on from that, you can see in yellow here, we've got the idea of the legal concept or the principle and some legal terminology as well. So I've provided some information about Christian Porter, the Attorney General at the time. He ordered that the Director of Public Prosecutions seek his direct written approval before journalists were prosecuted for alleged offences. And then I have analysed this. I'm not just saying what is happening, but I'm thinking about what this means from that legal principle viewpoint. And I've said this requirement is not aligned with the principles of the separation of powers and interferes with the implied right of press freedom in the Australian Constitution. So you can see here how it's important to not only just list examples and list things that are happening, but also look at it in more detail and what it means. Some more. So we've got citing some relevant legislation. So the Telecommunications and Other Legislation Amendment Act 2018, and this other amendment, Data Retention Act as well, impede on journalists' code of ethics. And in blue, we've got some analysis and an explanation of how that legislation impedes on the codes of ethics. So you want to not only just make claims, but support those claims with some evidence as well. It's like a persuasive speech in English, where it's far higher level and far more sort of credible if you not only make statements and claims, but then support those with the evidence to back it up. So I am citing the MEAA Journalist Code of Ethics. I'm stating some information about other legislation and what that means in terms of this idea of impeding journalists' code of ethics. And I zoom in as well. I say the Data Retention Amendment particularly comprises the obligations of journalists, allowing 22 government agencies to access metadata without a warrant. So note here that there's two other subheadings in this nature and scope section that I haven't included in these slides. So we are now moving on to the next section. So stakeholder perceptions. I started off with a paragraph about the stakeholders who were affected by the situation. I list a whole bunch of those, and that is a way of also analyzing that nature and scope too. I define a key stakeholder, so journalists are a key stakeholder here, and I provide that definition of who they actually are in this case, explaining how legislation affects them and how this relates to the legal issue of press freedom. So they are a predominant stakeholder in the national security amendment laws, as they risk being indicted with an unauthorized disclosure offense for reporting on particular information, and this presents a threat to journalists' sources and thereby press freedom in Australia. And this is continuing on from that. I also name and define another stakeholder. So I'm talking about Australia's National Security Agency, the Australian Security Intelligence Organisation, and then I again explain how the legislation affects them and how it relates to the issue. Try to, like in English, how you constantly need to refer back to a thesis statement that you would have introduced earlier in your introduction. In this, you want to make sure that you've constantly got the relevance to what you're talking about. So anything that you say, try and relate it back to the issue that you're focusing on. You don't want to get off track and too far away from the topic at hand. And then I've got another heading with the different viewpoints of stakeholders. So I've provided that detailed outline of who all the stakeholders are, how they're defined, how they're affected, and then I've got this more of a summary paragraph to just zoom in particularly on the viewpoints of the two stakeholders that I'm focusing on. Next section is the legal alternatives to reform the law. The first one that I've got is a Media Freedom Act. So again, making sure that it's a legal alternative, not just a recommendation that is not legally binding. So start off by clearly stating the legal alternative so it's really clear. Explain the advantages of the alternative. Explain how it could work. You could also delve into possible disadvantages if there are any as well. And that is something that I did do here. Oftentimes, since you're suggesting these legal alternatives, there's probably going to be more advantages to talk about than disadvantages, one would hope. But there often will be disadvantages to discuss as well. And my second alternative, a federal charter of rights. And you can see the level of detail that you want to go into there as well. In the recommendations section, I first off state an advantage of the legal alternatives that I am not choosing. So while a Media Freedom Act may be useful in the immediate future, a federal charter of rights is the most advantageous reform alternative. So I'm clearly stating that chosen legal alternative rather than sitting on the fence. And you can do that the way that I've done it. So you are recognizing a benefit of the other one that you're not choosing, if there is one in your case. Next up, I explain why this alternative is better than the other one. And then I finish off by providing another interrelated legal recommendation and some supporting reasoning. So if your legal alternative comes with possible concerns, so in this case, concerns about the restrictions of a Charter of Rights, that this idea of parliamentary sovereignty, I suggest using the dialogue model belonging to the Victorian Charter. So if you're making further recommendations, make them like sub-recommendations to the one that you've already said. So here I've suggested the Charter of Rights, and then I'm making further recommendations about how that could actually work to address some concerns that may exist around that. And then I finish off with a conclusion. This is really quite short. You will have covered most of that important information earlier, so you're just summarizing here with showing the importance of the change and what the change is. And our last question for today, so use your research skills to find a case law example on drug possession that was heard in the Queensland Supreme Court. Name the case and the date. So we'll have a look soon at some examples of places that you can go to help you in that kind of research. So when you're researching, make sure that you research widely and thoroughly. So don't make the mistake of just looking something up and just choosing the first couple of links that appear and not going beyond that. Just because it's at the top of the search results page doesn't mean that it is always going to be the most suitable for you. Also use a variety of sources. There's lots of different options out there, so look widely. If you don't have primary sources, it's going to be hard to do well. So primary sources can include law reviews, journal articles, law digests, all sorts of different things. Now, there's free legal databases that are available to you that can help with question 10 that we just looked at. There's Queensland Judgments, the Federal Register of Legislation, Supreme Court Library of Queensland, and the Australasian Legal Information Institute. Also, using news articles is something that's really handy. So I recommend using them as a starting point for your research. So rather than trying to find a case study, which can be difficult navigating different databases and figuring out the different ins and outs of that, you can try to find a news article that talks about a case study and then find and read the case. That way you'll be able to put in the name of the case into the database or the year or the people involved, so you've got something to actually search for and narrow down the results that will appear. And so it's going to make it quicker and easier to find and understand the cases as well. The news articles will likely explain what the situation is and hopefully will do so in language that's easier to understand than the sort of legal language that they'll use in different cases. In terms of referencing, so when you've got a report like this, it's really important that you keep track of referencing. This report is all about research, so you're going to have quite a few sources. I recommend doing formal referencing once you finish the final copy of your assignment. So if we have a look at my system, so I keep a record by having a bit of a table with a code system. So you don't need to have all of the columns in this table. You could just have the code and the URL or the publisher. But if you assign a code, either a number or a letter to the source, then in your draft, you can be putting ref, which stands for reference, ref A, ref B, ref C, and that can then, you then know, okay, this particular information was from this source, and you go back to your table and find the URL for that. And then if you're doing research notes before you start writing your report as well, you can organize your information into tables. you can have the title of your notes and then add the notes and the reference where you found it. So instead of needing to put this big URL everywhere next to information, you can just put that code that you've chosen instead. You can see in the draft section here, I've got that ref B idea. And then in the final submission, I then have the proper referencing with the name of the organization and the year. So this is something that's useful to do with in the draft, just having the informal referencing, because for me, I needed to make lots of changes before I did my final submission because I would always go over the word count. So there would be stuff that I would have to get rid of. And if I spent lots of time doing all the formal referencing for my draft, then I would be then getting rid of some of that work, because inevitably some of those references I would no longer need because I would be getting rid of information to reduce the word count. So that's why I would always wait till my final submission to do that formal referencing. When it comes to drafting, make sure you don't underestimate that. So try to have a complete draft that you can give to your teacher, because the more that you hand in that draft, the more feedback that you're going to get, and it's going to be easier to understand what you need to do to improve your work. I didn't discover the QCEE and all the resources on their website until very late on in the piece when it came to my external exams for Year 12. But I recommend, if you haven't already, go to the QCEE website, and not just for legal studies, but for all of your subjects. There are some handy documents there. So you'll have the syllabus for each subject. So it'll show you how you'll be assessed, what you're supposed to be taught, and the different glossaries and things like that, with showing you what different things mean. There are all the marking guides and rubrics and things. There are also exemplar reports on the website, so you can see the different examples of how an inquiry report would be done and that kind of thing. And then there's also a sample assessment instrument. So that is the sort of task sheet that you would get for your assignment. And if you visit any of those QR codes, you can see that they will take you directly to those PDFs as well. Thank you everyone for coming along to today's lecture. I hope that it was helpful for you. I encourage you to keep a hold of these slides and use them to help you with your study and with your assignments. Particularly reading through in full that example can give you some hints and tips for how to approach yours. And make sure you save that list of different resources that you can go to find cases as well. Thank you, everyone, and good luck with the rest of your studies.